Hello, everyone, and welcome. I'm Alonzo Martinez, Associate General Counsel at HireRight, and this is Fair Credit Reporting Act Basics, Background Screening 101, the first webinar in a series of 4 in our 101 series. As a reminder, today's webinar is being presented for informational purposes only. It is not intended as legal advice. However, it should provide you with a decent foundation and good talking points for you to advance your compliance journey as you discuss these issues with your teams and your legal counsel. As always, before we begin, I want to cover a few housekeeping items. In order to receive HRCI or SHRM credit, you must attend the full live session of this webinar. Credit information is going to be emailed to you next week. We are not providing copies of today's slides. However, when we send out your credit information next week, we will send you an email with a link to a recording of this webinar session. If you are experiencing any audio or video issues, please refresh the browser window by clicking F5 on your keyboard or send us a message using that Q&A icon at the bottom of your screen. Carrie and Doreen are producing today's webinar and will be monitoring the feed for any technical issues. After the presentation, we would appreciate getting your feedback. So please take our brief survey and let us know if this session was helpful. Like I mentioned, we're planning 3 more of these 101 style webinars this year, so your feedback will directly shape our future webinars. So take 60 seconds out of your day and let us know what you think. And again, please press F5 on your keyboard to refresh this presentation anytime you experience any audio or video problems. You may have seen on our title screen that joining me today is Nicole Campion. Nicole is a member of our legal and compliance team, and in addition to helping with many of HireRight's day-to-day compliance matters, she also helps create many of the resources we have available at the resource library. So join me in welcoming Nicole, and you can see the rundown on today's screen. Today, we've lined up what is intended to be an introductory discussion concerning an overview of the Fair Credit Reporting Act. That's the FCRA. While this discussion is certainly not going to be comprehensive in an hour, it should hopefully give you basic knowledge and familiarity with the foundation of the laws that regulate the background check process. So you can see it today. We're going to begin with a brief review of key terms that'll carry us through the discussion. We're going to walk through the FCRA's requirements in 4 steps, talk about reporting rules and state law considerations, and then talk about what the FCRA requires when you no longer have use for that background report. We should have plenty of time for Q&A at the end of the presentations, so use that Q&A icon liberally to get your questions in during our discussion. And with that, let me just hand things over to Nicole to kick off our discussion. Nicole?
Thanks, Alonzo. So we can go to the next slide, and we'll start with key terms. So this is just a couple of things that they're going to be really important for you to know as we go through the presentation. Terms that you'll hear us use quite a bit throughout the next hour or so. So some of these may look familiar to some of you, and some of them may be new. So I just want to cover them very quickly, and I promise I won't spend too much time on them. So first, the Fair Credit Reporting Act, the primary topic for our discussion today. You'll probably hear us refer to this mostly as the FCRA throughout the presentation. But this is what we're talking about. Really, this is what we're going to spend almost our entire hour on. So what is the Fair Credit Reporting Act? The FCRA is the federal law that governs the collection, assembly, and use of consumer reports and consumer report information. And we'll cover what that means in just a minute. But before we move on to the next definition, just a quick idea of why this is so important and why we have a whole hour to talk about it. The FCRA governs not just background screeners or credit bureaus, consumer reporting agencies. It also governs users of consumer reports. So employers who are using background checks as part of their screening process are actually covered by the FCRA. And we'll get into all of the requirements and the restrictions, or at least some of them, in the next hour. But that's why the FCRA is so important and why we've dedicated this hour to trying to get through as much as we possibly can. So what are consumer reports? You'll probably hear us use the term background report more often than consumer report. It's the term that seems to be most familiar to at least to the people that we usually interact with on a daily basis. So it's just what we're used to using. But when we say background report, we do mean consumer report. We'll use them interchangeably. And what that is it's a communication by a consumer reporting agency of information that bears on one of the 7 characteristics you see on the screen about a consumer, where the information is either used or expected to be used for a permissible purpose. So there are a few terms in there we haven't yet defined, so let's unpack it just a little bit. What is a consumer reporting agency? What does that mean? Well, that's someone who regularly assembles or evaluates consumer information for monetary gains, so either a fee or some sort of dues, or for a cooperative nonprofit on that kind of basis, where the purpose of doing this is really to provide consumer reports, background reports, to third parties for a permissible purpose. So what is a permissible purpose? A permissible purpose is one of the reasons that the FCRA allows consumer reporting agencies to give consumer reports to their users. So we will primarily focus on employment purpose in this presentation, but just know there are a lot of them. I think, don't quote me on this number, but last count, it was somewhere around 12 permissible purposes in the FCRA. Some will be familiar to you, things like insurance underwriting, which we've probably all gone through at some point, and some are a little bit more situational and not one you typically think of. But again, we're going to focus on employment purpose in this presentation here. And adverse action, you won't hear us use this term quite as much through the whole presentation, but we will have a section towards the end where you'll hear it a lot. So I just want to talk about it a little bit before we get there, so when we do get to that part, everybody has a pretty good understanding of what we mean by the term adverse action. So at a really high level, adverse action is any action that is unfavorable to the person the report's about. So I mentioned insurance underwriting as a purpose. In that space, it could be something like not underwriting the insurance or providing insurance but at less favorable terms, maybe with a higher premium. In the employment space, which again is kind of the focus for today, it could be things like not hiring someone, firing someone, not promoting them if they're up for promotion, and that's what you're using the background check for, things like that. So certainly not an all-inclusive list of what would be an adverse action in the employment space, but kind of give you a good idea of the things that might fall into that category. And the last term that we have to cover gets its own slide. There's so much to cover, and that is investigative consumer reports. So you may not hear this term too much throughout the presentation either, but it is a really important concept to understand. So I did want to talk about it really briefly. Investigative consumer reports are a type of consumer report, but they are a type of consumer report where the information in the report comes from personal interviews. So where you have that kind of general consumer report we talked about on the last slide, usually that information is going to come from some sort of factual record. So it may be a credit record, it may be a criminal record or other public record, could be driving records, but it's some sort of factual record. So it's generally pretty objective data. With investigative consumer reports, the information is coming from personal interviews with someone who knows about the individual, about their character, about their reputation. So the information is a little bit more subjective than what you would get in your traditional consumer report. And you're probably wondering why I'm telling you all of this. It's because it is important. There are actually different requirements for an investigative consumer report. So all of the things we're going to talk about today that apply to consumer reports apply to investigative consumer reports because they are a type of consumer report. But there are additional requirements that will usually apply if you're ordering an investigative consumer report. So we'll get into a couple of them throughout the presentation, but just really quickly, high level, you may see additional certifications you have to provide to your consumer reporting agency, additional pre-report disclosure requirements. And consumers actually have an additional right when you order an investigative consumer report about them that they don't have with your general, your kind of standard consumer report. And that is they can request an overview of the nature and scope of the investigation that was conducted about them. And of course, if they ask you for it, you have to give it to them. And there are some timing requirements in there too. So just a quick high-level overview, something to keep in mind as we go through this presentation. Again, we may not touch on it really specifically too much, but just be thinking about it and remember that investigative consumer reports are something to keep in mind. So Alonzo, I think that's really it for the really important terms that everybody needs to know. So what do we need to know about basics?
Yeah, so that is our terminology. Very quick, but let's dive into those basics. So what we have done is broken out the Fair Credit Reporting Act, FCRA compliance, into 4 steps. You can see them there on the screen, starting with certification and credentialing, to disclosure and authorization, to the pre-adverse action process and the adverse action process. Remember, Nicole just told us a little bit about what adverse actions are. We're going to tell you about how those play into the process. So our goal here is to tell a story that interweaves the law with some pointers from the Federal Trade Commission, that's the FTC, which is one of the regulatory authorities, or the FCRA, and also talk about some practical applications. So just stick through this with us. Keep getting your questions in so we can get a dialogue going. It's a great opportunity to learn from each other. With that, I'm going to turn it over to Nicole to walk us through step 1.
All right. So step 1, we're starting off with certification and credentialing. We're going to talk about these as one concept for the purposes of this webinar, but they may sometimes be different processes too. So what does this mean for users? What, as a user of a background check, can you expect in certification and credentialing? The first thing you're going to have to do is you're going to have to identify yourself to your consumer reporting agency or your background screening vendor. So if you're ordering a report on behalf of a business because you're screening applicants or current employees, you're going to have to give your consumer reporting agency some information about that business, like who they are and what they do. You'll need to certify your permissible purpose. So remember, these are the purposes that the FCRA allows consumer reporting agencies to provide consumer reports to its customers, the users. So you'll need to certify what you're going to use the report for. You'll also likely need to certify that you won't use it for any other purpose. And then your background screening vendor, your consumer reporting agency, they're likely going to verify your identity, the legitimacy of your business, and your purpose. They will obtain those certifications. So you have to provide the certifications, they have to get them from you. So they, of course, will do that. And then they're also likely going to have some processes in place to make sure that they don't provide reports to anyone who doesn't have a permissible purpose. A couple of notes on the certification piece here. There are 2 certifications on your screen here, but don't be surprised if you see more than that when you go through this process with your consumer reporting agency. Depending on where you're ordering reports, what you're ordering, there are a whole host of other certifications you may see. So it's entirely possible that you may have 4, 5, or 6 different things you have to certify to, and not just your purpose, and that you won't use it for any other purpose. This is actually one area where investigative consumer reports are a little different. So you will have some additional certifications in this piece of the process if you were to order investigative consumer reports. So those reports that have information that come from interviews. And I mentioned earlier that we were going to focus on employment purpose. So if that is your purpose for ordering reports, that's what you're going to be certifying in this step to your consumer reporting agency. So just want to take a quick minute and talk about what employment purpose means. What is it? How does it apply? Who does it apply to? All of those things. So employment purpose is defined by the FCRA as a report being used to evaluate someone for employment. It could be for employment promotion, reassignment, or even retention as an employee. So if we could go to the next slide, there's a couple pieces of information I just want to share about this that I think are really important. So there is some debate about the scope of employment purpose and whether it goes beyond just that really traditional definition of an employee. So independent contractors and volunteers are one area where there has been some discussion and some debate. So the 40 years report from the FTC gives us the FTC's view on this. And if you've not read the 40 years report, I do really strongly recommend giving it a look. It's a really, really good resource, especially for topics like this, where there might be a little bit of ambiguity or debate on the topic. So in their report, the FTC says employment is broadly construed. So it does cover non-traditional workers like volunteers and independent contractors. And in the report, the FTC actually gives us some examples of cases where they think they would say that employment would apply. So again, give those a quick look if you think this might apply to you. Now, at the same time, there's also some case law that says the opposite. It says completely different thing from what the FTC says, and says employment purpose does not cover independent contractors. So obviously a little bit of disagreement there. So this is one of those areas where it's going to be really important if you do use independent contractors or any other non-traditional employee, have a conversation with your consumer reporting agency and have a conversation with your legal counsel, and just make sure that you really understand the scope of employment purpose and how that may apply even to those non-traditional workers if you do choose to screen them. And last note on employment purpose, this is another area where in this step 1 on certifications, you may see some additional certifications. So if you're ordering for employment purpose, you may see a certification about your compliance with federal and state equal employment opportunity laws. You may also see a certification about your compliance with the FCRA's employment purpose pre-adverse adverse action process, and also disclosure and authorization process. We're going to cover what those are and what that means. Actually going to move right into step 2, and I'm going to turn it back to Alonzo to talk about the disclosure and authorization piece.
So now that you've certified a permissible purpose, let's look at that disclosure and authorization. Before requesting that a consumer reporting agency, a background check firm like HireRight, before you request that we complete a background report, you have to provide certain disclosures to the applicant. You have to let the applicant know that you're obtaining a background report on them for employment purposes, and then you also have to get the applicant's authorization to do so, to get that background check report. So on the screen, you can see in that bold text, I've highlighted a few key points from the FCRA regarding disclosure requirements. Again, these come from the Fair Credit Reporting Act. So before an employer can obtain a consumer report, a background check for employment purposes, the Fair Credit Reporting Act requires 2 key actions. First is a clear and conspicuous disclosure. So what does that mean? What is clear and conspicuous? Well, the employer has to provide the individual, the candidate, or the employee going through rescreening with a written notice stating that a background check may be conducted for employment purposes. And that disclosure has to be in a standalone document, meaning it can't be combined with other application materials. So like not part of that initial employment application, for example, or include extraneous information. Note the air quotes. I'll talk about that more in a minute. The goal here is really all about transparency. It's ensuring that the candidate knows exactly what's happening with your information, how it's going to be used as part of this background check for employment purposes. The second thing, in addition to the disclosure, the employer also has to obtain written permission from the individual before proceeding with that background check. So written authorization is our second step. This requirement applies before the report is procured or caused to be procured. That's just a fancy way of saying before the screening process begins. So before you make that background check request, you have to have the applicant's authorization. So let's dig into the disclosure a little more. Now, this is where a lot of employers run into trouble. Courts have made one thing very clear. Basic is best. At least that's how I like to frame it. The FCRA, the Fair Credit Reporting Act disclosure, it can't be buried in a pile of paperwork. It can't be hidden in fine print or packed with unnecessary legalese. It has to be clear, conspicuous, and stand on its own. There can't be any distractions, no extra language. So what should and shouldn't be included, you can see that on the screen. So what you'll typically see in an FCRA disclosure is that the disclosure itself should be pretty straightforward. The disclosure generally should contain these 4 elements: that you, the employer, are requesting a background report from a background screening company, the name and contact of the background screening company, the types of information that will be provided in the background report, and in some cases, if the background screening report will be an investigative consumer report, the consumer's rights to request additional information regarding the nature and scope of the report. Nicole told us a little bit about that when she was going through what an investigative consumer report is. So that's it. Just those four elements should be included within a standalone background check disclosure. Just the facts, no additional legal disclaimers, no company policies, and definitely no extra notices. Now, here's where mistakes happen and employers sometimes get it wrong. Sometimes employers try to add extra language into the disclosure. And we've seen in recent FCRA class action lawsuits that can lead to significant legal risk. This concept of non-compliant disclosures is a major target for litigation. So what's prohibited? You see it there on the screen. Pay attention. These are amongst the biggest compliance targets that you can have, starting with liability waivers or limitations of liability. You can't require a candidate to waive their rights under the FCRA as part of the background check disclosure. Courts have ruled that including a liability waiver, it invalidates the disclosure and it creates legal exposure. This is because a candidate can't consent solely to the background check with also agreeing to the limitations on liability. It's a twofer, right? You want them just to be able to agree to the background check, nothing else. Any additional notices not required under the FCRA, like extra explanations, disclaimers, internal policies, they should also be kept separate. If it's not part of the core background check disclosure, it doesn't belong as part of the disclosure process. And then state-specific disclosures mixed into the FCRA disclosure. Some states like California, for example, they have their own background check requirements. And you can't bundle state disclosures with the FCRA disclosure. Each has to be provided separately. So if you're going to just bear with me for one more minute, I just want to walk you through how the courts have ruled on this to provide a little context, a little practical application, like I mentioned at the beginning. I think understanding the why behind these limitations will help provide a deeper foundation, since getting your disclosures right is so critical. We're going to focus on a set of cases from the Ninth Circuit Court of Appeals that kind of leads the pack in terms of the foundation of law as it relates to background check disclosures and authorizations. And it's been very clear, the Ninth Circuit has been very clear on the standalone disclosure requirement. So we're going to quickly walk through three cases that I picked that provide the basis for what employers should and should not do, which again, you see up on the screen. First up, the 2020 Walker case, where the Ninth Circuit reaffirmed that the FCRA disclosure must be standalone. In that case, the employer included state law notices and an investigative consumer report disclosure in the same document. The court in that case ruled that even though the extra information was relevant, it still violated the FCRA standalone requirement. So think about that, right? This was relevant information to the candidate, but it violated the FCRA's standalone requirement. Super technical there. We also have a 2019 case, Gilberg, where the employer combined the FCRA disclosure with multiple state law disclosures. The court ruled that mixing in those state-specific notices violated that standalone requirement, making the disclosure not compliant. And finally, the 2017 Syed case, which focused on liability waivers in the disclosure. The employer included a waiver of liability requiring candidates to give up their right to sue over FCRA violations. The court ruled that this practice was unlawful, finding that the disclosure wasn't clear and conspicuous and violated that standalone disclosure requirement. So what do all of these cases tell us, and why am I spending so much time on this? The takeaway is simple. Employers, you really should resist the temptation to add in extra language to that standalone FCRA background check disclosure. Even if the additional information seems helpful, courts have been consistent. If it's not directly related to the background check disclosure itself, that you are conducting a background check, then just leave it out. And not to belabor this point, but many years ago, the FTC, the Federal Trade Commission, put us on notice concerning this concept of extraneous information. The FTC wrote in that blog piece that I have up on the screen now, titled "Background Checks on Prospective Employees Keep Required Disclosure Simple." And if you look at that first bullet in the red box, the FTC told us, don't include language that claims to release you from liability for conducting, obtaining, or using the background screening report. The FTC goes on to say, keep it simple. It's not just a good idea, it's the law. So we've talked a bit about the disclosure. What about the authorization? Can it be included with the disclosure? Well, up on the screen, I have the FTC's advisory opinion to Steer, which suggests that it can. You can see that in Mr. Steer's letter to the FTC, he states that it would be more simple and more direct if the disclosure and the authorization could be provided in a single document and the FTC agrees. If you look at that teal box at the bottom of the screen, the FTC said that an employer can comply with the FCRA by including the authorization within the disclosure statement. Nicole, because life is full of caveats, let's talk about exceptions.
Sounds good. Yes, the FCRA does contain one limited exception for some DOT regulated roles. Before we get into what it is and how it applies, I just want to make sure to cover really clearly the scope of this. So this is a very limited exception, and it's an exception to some of the employment purpose requirements. It's not an exception to the FCRA overall. So if you hire someone who qualifies for this, it doesn't mean the FCRA doesn't apply and you can use the report. And however you see fit, the FCRA still applies. But there may be some modified procedures for some parts of the employment purpose process. And we will cover those in the next few minutes, next few slides. So what is this? When does it apply? This applies to candidates who are applying for positions where the U.S. Secretary of Transportation can establish maximum hours of service and qualifications under the section of the U.S. Code that you see on your screen, or a position that's subject to regulation by a state transportation agency. And should be in bold with big stars around it because the and is really important. The only interaction that you as the employer have with the candidate about their application is through methods like mail, phone, email, something like that. And I say the and is important here because both of these things have to be true in order for the exception to apply. So just because you're hiring into a position that qualifies under the first bullet doesn't mean it automatically qualifies. The interactions you have with the candidate also have to qualify under the second bullet. You may hear me refer to this as the DOT exception, the regulated trucking exception. They all mean the same thing. I will do my best to use one term, but if I use different terms, please know they mean the same thing. This generally applies to motor carriers, which is where the regulated trucking nomenclature comes from. One last important thing to note on this before we get on to what it changes, this isn't a company-wide exception. So just because you hire people into positions that qualify for that first bullet, and then the interactions qualify for the second bullet, it doesn't mean that it applies to everybody. So for example, if you're a motor carrier and you hire someone into a regulated trucking position, you never talk to them in person about their application, you only email them, so perhaps they qualify for the exception. That doesn't mean that you can apply the exception to everybody else in your organization. So if you have office staff, secretaries, chances are they probably wouldn't qualify for this exception. So it's just really important when you're trying to figure out if this exception applies and which set of procedures you're going to follow under the FCRA, you really have to look on a candidate by candidate basis and make sure, as I said before, that both the position qualify and the way that you interact with the candidate qualifies. So what does this change? As far as the disclosure and authorization process that we're talking about in this step, it changes a little bit. The content of the notice doesn't really change. So you do still have to tell candidates that you're going to get a consumer report about them for employment purposes. The exception doesn't erase that requirement. But what it does do is change the format a little bit and the process a little bit. So like Alonzo mentioned, for your general pre-employment or employment purpose screening, you have to provide the clear, conspicuous, standalone written disclosure. When a candidate qualifies for this exception, you just have to provide a disclosure, a notice that is oral, written, or electronic. So it gets rid of that requirement that it has to be in its own document and it has to be in writing. You could do it over the phone or via an electronic method too. And really similarly with the consent piece, with your kind of general employment purpose screening, you've got your written authorization before you order the report. If a candidate is subject to this exception, that consent can be oral, written, or electronic. They do use different terms. You have disclosure and authorization for regular employment purpose reports and notice and consent for the DOT regulated ones. But similar ideas, similar concepts. You still have to do the things that underlie the requirements. You still have to provide the notice, or the disclosure, and you still have to get the authorization and consent. But it does change how you do it a little bit, and gives those who have people being hired into these types of positions another option, basically, for compliance. So Alonzo, at this point, I think we've kind of gotten through the early stages. This is kind of where people would order their reports, review their reports, and make their initial decision. So if an employer were to decide that they might not want to hire someone based on their report, what do they need to think about?
Yeah, absolutely. And as we get into step 3, remember, keep getting your questions in using that Q&A icon at the bottom of the screen. We have a lot of you on the call today. The disclosure and authorization process can be tricky. And again, it is the #1 area of litigation, at least from my perspective. So get your questions in if you have questions about disclosures and authorizations, the DOT exception, or the credentialing and certification process that Nicole opened up with. So like Nicole said, we're moving through our background check life cycle. We've certified, we've gone through credentialing, we've certified our permissible purpose. We have provided a standalone disclosure that is clear and conspicuous. We have received authorization, either written or subject to the DOT exception. And now you have the background report in front of you, and you're looking at that background report, and you are potentially deciding not to continue with that individual's employment, whether it's that conditional offer of employment or their continued employment with your company because of something on that background check report. So that is step 3, the pre-adverse action. So let's say you're considering denying someone a position with your company based on their background report. This is exactly where the pre-adverse action process comes into play. Now, here is something important. You have to follow this process if you're using the background report, quote unquote, in whole or in part, to make a potentially negative employment decision, a potentially adverse employment decision, to use one of our terms today. So what does this mean in practice? Well, maybe the candidate has a criminal record that gives you pause. Maybe they don't have the right qualifications for the role, or maybe there's something in their employment or education history that doesn't align with your hiring criteria. Whatever the reason, if the background report plays into any role in the decision, the FCRA requires you to take specific steps before making a final employment decision. So what do? Before you communicate anything to the candidate, you have to provide them with a pre-adverse action notice. And that notice must include 2 things. 1, a copy of the background report that you used in your decision-making process, and 2, a copy of the CFPB, the Consumer Financial Protection Bureau's summary of rights under the Fair Credit Reporting Act. The CFPB is one of the other regulators, in addition to the FTC, the Federal Trade Commission, that regulate the FCRA, the Fair Credit Reporting Act. So why do you have to provide the candidate with these 2 things? Because the FCRA gives candidates the right to review their report, and if they believe anything is inaccurate or incomplete, to dispute that information with a background screening provider such as HireRight. This is a really important step because it helps to ensure fairness in the hiring process, and it gives candidates that opportunity to correct any errors before you, the employer, potentially makes a final adverse employment decision. So what does the FTC have to say about this? The FTC has outlined this in very simple terms. You can see point 2 in that red box on your screen. If the background check reveals something that may lead you to deny employment, you must notify the candidate of the results and provide them with a copy of the report. And here's a key part. You have to give that candidate or that employee time to review the background check report. This gives the candidate an opportunity to challenge any information they believe to be inaccurate or incomplete before a final decision is made. Nicole, because the DOT is different, why don't you walk us through the exception?
Sure.
Oh, actually, I guess I have one more point to make here. I apologize. Before we move on to that exception, you heard me say that the employer needs to wait a reasonable amount of time before the pre-adverse action notice and that final adverse employment decision is made. So what's considered a reasonable amount of time? That exact question was asked, and you see it here on the screen in the FTC's advisory opinion to Weisberg. And in that letter, the FTC agreed that 5 days appears to be reasonable, that waiting period. Now, keep in mind, the Fair Credit Reporting Act doesn't specify an exact waiting period, but 5 days has generally been considered a best practice to give the candidate enough time to review the report and dispute any inaccuracies if needed. There are, of course, some exceptions to that. We're going to cover those a little bit later, but now, Nicole, we'll hand it over to you to cover the DOT exception.
Sounds good. So this is another area where that DOT exception or regulated trucking exception provides some modified procedures. And this one's a pretty big change, actually. So like Alonzo mentioned with your standard employment purpose consumer report, to provide that pre-adverse action notice, you have to wait that reasonable period of time. For positions that are subject to the DOT exception or the regulated trucking exception, neither of those steps actually exist. So you are not required to provide a pre-adverse action notice. You are not required to wait a certain amount of time in between the notices because there's actually only one notice. So the adverse action process does look a good bit different for positions that are subject to this exception. I don't want to jump too far ahead. So Alonzo, do you want to cover the general adverse action requirements before I jump into the exception on that piece?
Sure, let's do that. So let's talk about step 4. Let's say you've given the candidate that opportunity to review their background report at least 5 days unless longer is required by state or local law. You've given them the opportunity to dispute any inaccuracies with the background check provider, and you've given them the opportunity to provide an explanation to you as to why, or you've provided an explanation to them as to why you're potentially moving to withdraw that conditional job offer or terminate their employment, for example. And you've ultimately decided to move forward with that final adverse decision, denying employment. We are at the adverse action process. Again, this step applies if you're making your final decision not to hire, contract, or allow somebody to drive for you in whole or in part based on information in their background check. At this step, you have to provide the candidate with a final adverse action notice that includes those 4 elements that you see on the screen. First, a description of the adverse action. This makes it clear that the candidate is being denied employment for the position that they applied for. Second, the contact information for the background check firm, HireRight in this case. This is the firm that provided you with that background report. Third, a statement that the background check vendor, HireRight, did not make that hiring decision. This is important because the background screening provider only supplies that report to you. We don't decide who does or does not get hired. And fourth, the candidate's notice of rights under the Fair Credit Reporting Act. This informs the candidate that they have the right to request a free copy of their background report within 60 days and dispute any additional inaccuracies directly with the screening provider. Once that notice, this adverse action notice is provided, that's it. The adverse action process is complete and the hiring decision is final. That's everything from the adverse action perspective. Quickly, because I like to reference the FTC. They also cover this in their blog. You can see that in point 3 in the red box on your screen. If you decide not to hire somebody, you must provide them with a final notice stating that your decision was based, at least in part, on information from their background check. Again, this step is critical because it really helps to ensure that transparency and give the candidate a clear understanding of your decision. It also serves as a reminder that the candidate has a right to request a free copy of the report and to dispute any inaccuracies with the background check vendor. Nicole, let's get back to that DOT adverse action process.
Sounds good. Okay, so for positions subject to this DOT exception, I mentioned the adverse action process looks a bit different. And really it is in the process. That's where the main difference is here. So when you have a position subject to this exception, you still have to provide an adverse action notice. Content-wise, that's really similar to what you would do for any other consumer report. So you're going to have to notify the candidate that you're going to take adverse action based on the report, give them the information for the consumer reporting agency, that really important statement about how the consumer reporting agency didn't make the decision and can't give reasons for it. And you still have to give the consumer information on their rights to dispute and their right to get a copy of the report. So content-wise, again, really not that different. Process-wise, really that different because this is the only notice you have to give. So instead of that multi-step process where you're giving a pre-adverse action notice, then you're waiting, then you're giving an adverse action notice. For regulated trucking exception positions, you're giving one notice within 3 days of adverse action. can be oral, written, or electronic, so that piece isn't that different either. But again, major difference in process, no major difference in content with the adverse action piece. So with that, I think we're at the end of our 4 steps. So we went through certification and credentialing. You provided your identity, your purpose. You made all the certifications your consumer reporting agency requires. You provided your consumer their disclosure. You got their authorization. You ran the report, and then you made your decision. So you either hired them or you made the initial decision that perhaps you weren't going to want to hire them based on the report. If that was your decision, you gave them their pre-adverse action notice. As long as it wasn't a regulated trucking position subject to the exception, you waited that reasonable period of time, and then you send them your adverse action notice. So that really is kind of a quick overview of the 4-step process and some important pieces to keep in mind. So Alonzo, I know we want to switch gears to another really important topic for FCRA basics. Do you want to take us through some reporting rules?
Yeah, absolutely. And again, please keep getting those questions in. This is your session, so we're going to have plenty of time at the end of today's session as we're motoring through, DOT pun right there, our presentation today. So get those questions in, and we will cover those at the end. So like Nicole mentioned, let's move on to some nuances that impact background screening and compliance, starting with those reporting rules. So let's talk about how long adverse information, again, potentially negative information, can be reported on a background check under the FCRA. So the FCRA, the Fair Credit Reporting Act, it sets very strict limits on how long this information can be reported, but there are some key exceptions employers need to be aware of. But before we get into those exceptions, let's talk about that general rule. That general rule is a 7-year reporting limit on adverse action or on adverse information. So again, any potentially negative information, generally reportable for up to 7 years. Now, for most types of adverse information like civil judgments, tax liens, collections, and non-conviction criminal records, again, non-conviction criminal records, not criminal convictions, the FCRA limits reporting to that 7-year period. Once those 7 years have passed, this information has to be excluded from the background check. We can't report that to you after 7 years. But there is no time limit for the reporting of criminal convictions. So long as they're available at the source, like the court, for example, they can be reported to you. Again, unlike most other adverse information, criminal convictions can be reported indefinitely under the Fair Credit Reporting Act. This means that convictions are going to appear on a background report no matter how old they are, unless state laws impose stricter limits. However, from a HireRight perspective, this depends on the search depth that you've implemented on your screening account. I think that that's going to be a question for a lot of you. So ask us questions if you have questions about search depth and how that might apply to criminal history reporting. Bankruptcies, they can be reported up to 10 years. And while most financial related adverse information follows that 7-year rule, bankruptcies, like I mentioned, have a longer reporting window. They can be reported for up to 10 years. Not a lot of folks actually use bankruptcy information, but if you do, again, 10 years. There is one more major exception to be aware of, and that is the salary exception, which you see on the screen. If a candidate is applying for a job where they're expected to earn an annual salary of $75,000 or more, then the 7-year reporting limit does not apply. Again, this is the expected salary, not their actual salary. So in these cases, background screening providers like HireRight can report adverse information older than 7 years, which allows you to see a longer history of the candidate's background. From a HireRight perspective, it's important to remember that we offer different search depths. Again, the default is that 7-year period, but that's configurable, as well as the option to enable a salary exception on your account. So for example, is the individual expected to make $75,000 or more? All of those things can impact the amount of information, criminal information, for example, that we can provide to you. So let us know if you have questions about that, or if you need help with your account configuration specifically when you complete the survey after today's presentation. So let us pivot back to some state issues. In that last section, we covered how the FCRA allows adverse information to be reported beyond 7 years for positions with salaries of $75,000 or more. But as we often see in compliance, state laws don't always align with federal rules. So while the Fair Credit Reporting Act sets that baseline, states have the power to set stricter limits or different salary thresholds for reporting older adverse information. That means in some states, even if a job pays over $75,000, that 7-year limit may not apply. And that's exactly what you see there on the screen. So California, Montana, and New Mexico, no salary exception applies. In these states, the 7-year reporting limit applies to all positions, no matter the salary. Even for higher paying roles, adverse information older than 7 years cannot be reported. Internally, we call these the 7-year states. In New York, the salary exception kicks in at $25,000, meaning that for jobs paying $25,000 or more, older adverse information can be reported. And in Washington, Maryland, New Hampshire, and Kansas, these states have even lower salary thresholds of $20,000, meaning adverse information older than 7 years can be reported for jobs paying $20,000 or more. So remember, if your company is a multi-state employer, you operate in multiple states, you may need to tailor your background screening policy, how you consider information, based on the information that we can report to you against these salary exception variations. So again, while the FCRA provides this general framework, state laws can override or modify these rules. So now that we've kind of covered these state level variations, let's talk about further restrictions at the state level that impact the reporting of potentially adverse information. So while the FCRA generally allows criminal convictions to be reported indefinitely, certain states limit reporting to 7 years, meaning that older criminal convictions can't be included in a background check, even if the FCRA would otherwise permit it. I alluded to this a second ago, calling these the 7-year states, and that's exactly what you see on the screen. So again, even though the FCRA generally allows criminal convictions to be reported indefinitely, in these states, the reporting of criminal history information is limited to 7 years. So that's exactly what you see on the screen. Now that we've covered these state-specific restrictions, I'm going to hand it back over to Nicole to cover some additional state law considerations beyond these reporting restrictions. Nicole?
Yes, so there are quite a few. We've talked a lot about the FCRA, and I know this is a webinar about the FCRA, so I won't spend too much time here, but I do think it's really important to at least mention some of the different types of state laws that may impact an employment screening program. Because it really doesn't end with the FCRA. There's a lot more that you're going to have to think about. So Alonzo mentioned that there are states that have their own version of the FCRA, and those, impose some additional reporting restrictions. They can also impose some additional requirements on users, things like additional pre-report disclosures that are specific to that jurisdiction. You have anti-discrimination and equal employment laws. So you have Title VII at the federal level. States also typically have their own version. And important to note, some of them specifically call out discrimination based on criminal history. So be sure to keep that in mind as you are working through your screening program. Ban the box and fair chance hiring laws. These are big ones. They really can impact so many different stages of an employment screening program, from what you can say in your job postings and to your employment applications. Right? Ban the box laws really get their name from their primary goal, which is to eliminate that box, ban the box on employment applications where you're asking a candidate to disclose if they've been convicted of a crime. They can impact what types of criminal history you can consider in an employment decision. And they really can impact basically the entire pre-adverse and adverse action process, from what you can say in your pre-adverse action notices or what you need to include, to how long you need to wait in between notices, to what goes into your adverse action notice. So we could probably spend at least an hour just talking about those laws. There's just so much to unpack with them. So big ones to keep in mind. We do have a resource on ban the box and fair chance hiring laws that break these down jurisdiction by jurisdiction and give a bit more detail. So I encourage you to give that a look. Clean slate laws. These are newer, at least newer than ban the box for the most part. What these do is they typically will automatically either seal or expunge, whichever one the state uses, certain types of criminal records once the record and the consumer meet a set of qualifications. So you may see something like a state that would expunge all misdemeanor convictions after 5 years, so long as it wasn't a domestic violence offense or sex offense, and the person isn't on the sex offender registry or in prison. Something along those lines. This is another one that varies a lot from state to state. We also have resources on these, so I encourage you to give those a look as well. And these are, you're probably wondering why this is important. These are important for a bit of a different reason than some of the other ones are. Clean slate laws, because they seal or expunge records, right? Once that happens, that record typically doesn't appear on the public record index anymore. If it's not on the public record index anymore, most employers can't get to it, and most background screening providers can't get to it. Obviously, if we can't access the record, we can't report the record to you because we can't get it. So it's really important to just keep these in the back of your mind and make sure that you're somewhat familiar with them and know that they exist. Credit history restrictions. These laws typically restrict an employer's ability to use someone's credit history as part of an employment decision. Most of them will limit employers to a set of reasons why it is acceptable to use credit history in an employment decision. And some of them will also impose some additional pre-report disclosure requirements. Typically, you need to tell the candidate which of that set of reasons you're going to be relying on to order their credit history. Pay equity laws encompass both salary history bans and pay transparency laws. So your salary history bans typically would prohibit an employer from inquiring into a candidate's prior compensation history and then using that as part of the decision-making process when making an offer. Pay transparency laws will often require employers to disclose things like compensation ranges in job postings. And cannabis laws. I think these are less commonly associated with employment screening. I think it's not one people think about all the time, but they are important really for a few different reasons. First, going back to the clean slate laws, some of them will seal or expunge cannabis-related records when that particular thing is not a crime anymore. So in states that have decriminalized marijuana or cannabis, sometimes those will no longer appear on public record indexes. There are also some cannabis laws in some jurisdictions that may impact an employer's drug screening program if you test for marijuana or cannabis. So just things to keep in mind there. So going back to our 4 steps, what do these all do for our 4 steps? Where are the impacts seen the most? In the credentialing and certification process, that first step, you may see some additional certifications that you have to provide to your consumer reporting agency based on jurisdiction or the types of products you're ordering. In the second step, your disclosure and authorization process, you may see some additional pre-report disclosures that are specific to the jurisdiction. You may be required to provide candidates a checkbox that they can check to request a free copy of their report. So this is California, Minnesota, Oklahoma. And in jurisdictions that require you to have a bifurcated screening program, so think New York City, you may need to think about what you can and can't put in the disclosure and authorization documents that are associated with each stage of screening. So usually it's your non-criminal screening before your conditional offer and then your criminal screening post-conditional offer. So something to think about there. And then in the third and fourth steps, your adverse action process kind of as a whole, you may have a mandated waiting period between your pre-adverse and adverse action notice. So where the FCRA says a reasonable period of time or requires that you provide a reasonable period of time, your ban the box and fair chance laws may require a minimum of 5, 7, 10, or some other number of business days between notices. You may be required to conduct an individualized assessment, and there may be specific things you have to consider in that assessment. You may also have to give the candidate a copy of the individualized assessment. And you may have jurisdiction-specific notices. So there may be requirements for what has to go into your pre-adverse and adverse action notice. Things like you may need to identify the offenses that disqualify someone, or you may need to give the consumer or the candidate some information about how to file a complaint with the relevant authority. Things like that. Again, these vary a lot from jurisdiction to jurisdiction, but kind of the high level 30,000 foot view of what you may need to think about. And then outside of those 4 steps, you may see impacts in your job postings. So things you have to say or can't say. So you may need to disclose compensation ranges under some of the pay equity laws. You may be restricted from making mention of criminal history under Ban the Box Fair Chance laws. Content restrictions, things you may need to think about as far as what you're looking into. There may be things you're not allowed to consider. So previous compensation history, credit history, certain types of criminal history, of course, all depending on which jurisdiction's law applies to you. And last but not least, cannabis laws. Again, keep those in mind. If you have a drug testing program that includes marijuana or cannabis screening, some jurisdictions' laws may impact drug testing. All right, Alonzo, do you want to wrap us up with what we do when it's time to dispose of consumer reports?
Absolutely. And Nicole, if you'll take a look at some of the questions coming in, we'll briefly get to those in just a minute here. So we've talked about how we've covered this, what a consumer report is. Nicole has walked us through the process, but what happens after you no longer need this background check report? Well, remember, we don't want it to get into the wrong hands. It has all sorts of information about all sorts of people. So we need to make sure we dispose of it in a proper way. You can see how to dispose of it on your screen, such as shredding, burning, or pulverizing these documents, erasing or securely deleting electronic files, and also using a certified document destruction vendor. Again, we want to make sure that we protect consumer data. You can't just throw this away. You can't simply archive a file. Once you no longer need this information, please dispose of it in a responsible way. It is very, very important information that needs to be treated as such. So with just a few minutes left, let's dig into that Q&A. Nicole, do you have the first question up for us?
Sure, we have a lot of really good questions. First, we have a whole bunch of questions around where to find HireRight sample documents and account setup type questions. If you have a question on how your account is set up or how you can access certain features in your account or where you can find our samples, I recommend reaching out to your customer service representative or to account management. They're going to be able to help you probably much better than we can. So our first general question, we actually have a few on this topic, and it's a really good question that I think, Alonzo, you and I talk about quite a bit. If someone presents the disclosure and authorization the first time and runs the background check, hires the person, and then they later need to run another background check, either for monitoring or promotions, whatever the case may be, do they need to go through that disclosure and authorization process again? Or because they did it before the first one, can they just rely on that?
Sure, I can briefly take that. So many disclosures and authorizations contain what's called evergreen language. If you are referencing HireRight's sample disclosure and authorization documents, it does include that evergreen language. So that means you can continue to rely on that disclosure and authorization for as long as you have a permissible purpose. So for example, for as long as that individual is employed or contracted with you. There are some caveats, of course. States like California are unclear with the concept of evergreen consent. So California, for example, requires that you provide a disclosure every time you run a new background check, but it doesn't actually cover the concept of authorization. So as a best practice, you'd want to provide a disclosure and authorization every single time. I think that is generally a best practice, but again, you'll want to look at your own disclosure and authorization documents to see if they have that evergreen language. Again, HireRight sample forms do include that evergreen language.
All right, the next one we have a couple of times is kind of about the general scope of the FCRA and what it applies to. So if we have someone who orders just a drug test or just a driving record, does the FCRA apply there, or is that outside of the scope of what we would consider a consumer report under the FCRA?
Yeah, so from a HireRight perspective, remember that HireRight is a consumer reporting agency under the Fair Credit Reporting Act. We assemble and compile information and provide it to you, a third party, right, at your request upon your certification. So anything that we provide to you generally anything that we provide to you outside of the scope of like I-9, for example, is a consumer report, because this is information about that consumer that we're providing to you. So that drug test, if provided to you by HireRight, that driving record, if provided to you by HireRight, would be considered consumer reports that would be subject to the Fair Credit Reporting Act. So you need to follow the disclosure and authorization, the pre-adverse, and the adverse action process. Nicole, we have time for maybe one more.
All right. The last one seems like a couple of questions just to clarify what's required for the adverse action process. So just to clarify, it is 2 separate letters: pre-adverse action letter, that reasonable period of time unless you have a mandated waiting period under a fair chance of ban the ballot box law, and then the adverse action letter. So we got a couple of questions on whether it was really 2 letters or not. It really is 2 letters, yes.
And with that, we're just about at the end of our time. So if you submitted any questions, we'll include them in a blog that recaps this webinar. And as always, we really appreciate the engagement. We covered a lot in this session. And whether you're new to background screening or you've been at this for a while, I hope that there was something today that caught your attention and gave you some new perspective. Before you log off, please do us a favor, take a quick minute to complete that survey at the end of the webinar. Your feedback really helps to shape these sessions. And again, look for an email with your SHRM or HRCI credit next week. So with that, on behalf of Nicole and myself and the entire team here at HireRight, thanks again for spending some time with us today. We appreciate it. We'll see you next time for another Compliance Webinar 101 webinar. So thanks again, everyone.